Well, you've seen argument today and on Monday over this issue of whether a witness in the Newzroom murder trial may be able to testify without her testimony being broadcast live. Lots of arguments in different ways on this. We do now expect some kind of outcome to all of this tomorrow, whether it's a decision by a judge or some kind of arrangement between the various sides in this. Kelly Phelps is a legal analyst. She's been watching the interviews play out. Kelly, good afternoon to you. There's so many interesting arguments here. You have the public's right to see a court proceedings. You have a witness's rights as well. What for you is going to decide this?
Well, I mean, I think what will decide it is the validity underlying this particular application. I think it's important to note that a lot of the commentary around this application has been almost somewhat dismissive, focusing on the fact that the person making the application is supposedly in the public eye already, and there's been some innuendos that therefore it's a bad faith application. But I think it's important not to let that overshadow the very important issues that lie behind things, the issue of whether witnesses should be broadcast live while they're giving testimony. It's not an unreasonable request for a witness to not want to be subjected to that level of scrutiny. Being in court is already intimidating enough. And then having to do so with the knowledge that you're being broadcast live adds a whole nother level of intimidation. So I think the argument is a fair argument to make to say that a witness doesn't want to be broadcast live. Whether the particular arguments that have been put forward with regard to this witness are reasonable, I think remains to be seen. I think it's most likely that at the very least they will require that some audio is permitted.
So there's been, as you say, a lot of commentary on all of this, and I haven't been able to see all of the legal arguments myself. But how important is the issue around the course of justice to this? So if a witness said they would give better, more accurate testimony if they were not being broadcast, I would think for a judge that would be a really important aspect.
Yes, absolutely. I mean, that's a critical aspect. Another really important aspect to take into account when deciding whether to broadcast witness testimony is also the ability of other potential witnesses who are yet to testify to see that testimony and potentially have it contaminate their later testimony. That hasn't been focused on as much as I would have expected it to in the legal arguments put forward in court with the applications. There seems to have been more of a focus on matters like worrying about damage to reputation and damage to the witness's professional standing. I think those are less persuasive because that could be the case for any witness who testifies in a trial that is simply reported on, even if it's not broadcast live. But I think the question of the intimidation factor weighing on a witness and actually interfering potentially with the quality of that witness's testimony is really critical to the question of the administration of justice and the right to a fair trial. And, you know, I think the press often seem to, in the commentary around this case, seem to be overblowing the question of open justice and the right of freedom of expression and in particular freedom of the press, which is of course absolutely critical, but it's no more critical than the competing rights in this matter, like the right to a fair trial and also the proper administration of justice. And of course, all members of the public have an interest in the proper administration of justice. So we do need to take these sorts of applications really seriously.
There's so many different things around this. I mean, I think we've sort of become used to in these high-profile trials being able to see it. And I mean, that's fine. I understand why. That's one of the reasons we broadcast it. We see it as important. There are other things, though. I mean, I could imagine someone might say they fear ridicule. Maybe they speak in a particular way. Maybe they think that people are going to make fun of them on Twitter. Their right to dignity would thus be damaged as a result. Maybe, you know, and you can imagine what happens in a national conversation. The fact that someone reacts to a question in a particular way, dresses in a particular way, all of these things can suddenly, you know, be the figure of a national discussion. During the Oscar Pistorius trial, someone made a rap song based on how one of the lawyers was speaking, one of the phrases that he used. So what I'm trying to get to is, could someone simply say, I fear ridicule, and is that a strong enough reason for it not to be broadcast?
It could potentially. I have to say two things about that. The first is we have come to see this as a regular thing, broadcasting criminal trials live since the Pistorius trial. But I think it's worth noting that actually it isn't at all. This is actually a feature in our very recent history in South African law. The Pistorius trial was the first trial that was granted that kind of live 24-hour broadcast rights over the case. And what is interesting is that the judgment in that case that decided that the trial could be live broadcast was relied upon in the court today in arguments by the lawyers quite extensively. And I think it's worth noting that the judgment in the Pistorius trial itself didn't really pay much attention to previous cases that had come before when judges had decided not to permit live broadcast. So simply because we have a few recent examples where live broadcast has been permitted, we certainly shouldn't assume that that is the standard that one can expect. There's a very long array of jurisprudence that predates our recent history of live broadcast, putting forward some very strong arguments against it. And one of them would be things like witness ridicule and the impact that that could have on witnesses' ability to testify naturally and honestly in court. But I think the even more important one is the question of prejudgment. Because what can happen is that if the public watching a live broadcast feel that the answers to the complex legal questions and factual questions that are placed before the court are easily ascertained, and they jump to prejudge the case, and the judge eventually ends up ruling in a manner that doesn't accord with that vast public opinion, that itself can significantly undermine the administration of justice, because it can undermine, unfairly so, the legitimacy of justice in the eyes of the public. So we do have to make these decisions about what aspects of a trial to live broadcast and when to do that very carefully. And it shouldn't be a decision that is either taken flippantly, which it's clear from this judge he's taking it very seriously, but also it shouldn't be commentated on in a flippant way either. They're very important issues at play.
I hear you on that argument, and I understand that people will see something, hear testimony, and sort of make up a mind of it. And a legal person, a judge, this is why we employ judges, we have such a strict legal criterion and such a strict selection process for them, could go the other way. But doesn't your argument go the other way as well? So, for example, in the Zondo Commission, which I accept isn't a court case, but we all watched it. And when the findings came out, there was no surprise, because we had all seen the testimony of this person and that person. And so when findings were made against them, we understood why. And that gave that process legitimacy. Doesn't the same happen in a court process? If we see it in an open way and we see the testimony for ourselves and the judgment comes and we can understand, and I think judges have taken pains more recently to give clearer judgments, or judgments with less Latin and more English perhaps, that also bolsters the rule of law.
So I think it can, but I think it very much depends on how these things play out and how they're handled. So there's different ways you can broadcast, right? First of all, you can broadcast live showing the legal actors and the judge and the lawyers without showing the witnesses, members of the public who's simply fulfilling their civic duty in order to come and provide testimony. Secondly, there's a different level of press intrusion that you can allow into a trial. So, for example, I've been in courtrooms in 2 cases that have been live broadcast, one of which allowed 1 stills photographer and 1 live feed photographer, and another one hadn't put a limit on that. So the courtroom itself descended into somewhat of a circus. So there's different ways that this can be handled. It's not a matter of all or nothing. Should it be live broadcast or shouldn't it be at all? But rather how we approach this question. And I think the second important thing to remember is that not everyone watches every day of a trial play out. And that can be very damaging to public perception because, of course, because of the burden of proof in a criminal case, where the state has the burden of proving their case, they are putting their witnesses on the stand first. And only if they've met a certain threshold do the defense even have to launch a case against that. So if you've got the public watching quite sensational evidence at the beginning of a trial that is from the state, it is always only going to be putting one side of the case forward. And if they then don't continue watching every day of a trial, and trials can be incredibly long and protracted, as we know, then that can lead to a very skewed understanding of what they've seen. And it's very important, therefore, when trials are live broadcast, that journalists such as yourself, which you do a very good job of, put what is being seen in court on a daily basis in context so that the public can understand that this isn't the end of the conversation, it's just one point in a very long conversation, and that everything needs to be weighed in the balance in the final outcome.
It's amazing how interesting this issue is, isn't it, Kelly? There's so much to it. There is this one technical point I'd like to touch on. If the witness in this case is told by the judge that she has to testify on live television for whatever reason, and they really object, can they then appeal to the Supreme Court of Appeal? And if so, would that delay the case?
You know, I'm not sure what the answer is to that offhand. And the reason I say that is because we're actually in uncharted territory at the moment. As the the lawyers pointed out today in the courtroom, there's a lack of clarity around the legal status of this particular motion in court at the moment. There was some debate over whether this is a mere objection or whether this is a fresh application being launched. And until that is clarified, which will be clarified by the judge when he comes back, I believe, tomorrow in order to reach his decision, until that is clarified, we won't have clarity on if there is a where to next.
Kelly Phelps, thank you very much. Indeed, not the last time that this conversation, I think, is going to come up. We do expect, as Kelly said, a finding one way or another tomorrow. Kelly Phelps, legal analyst there. Well,